Oakland County OWI lawyer being charged with operating while intoxicated in Oakland County carries immediate risks to your freedom and driver's license, so prompt action is essential. Under Michigan's operating while intoxicated statute, it is illegal to drive when alcohol or drugs impair your ability, and the law uses OWI instead of DUI to describe this offense. The legal limit for most drivers is 0.08%, commercial drivers are limited to 0.04%, and drivers under 21 face a 0.02% limit under the zero tolerance law. There are related charges. Operating while visibly impaired requires only proof that alcohol or drugs visibly affected your driving, and operating with the presence of drugs can apply if any amount of certain controlled substances or cocaine is detected. Penalties vary, but even a first offense can lead to jail, significant fines, points on your driving record, and a suspension of your driver's license. Repeated or aggravated offenses bring longer jail or prison sentences, higher fines, mandatory ignition interlock devices, and revocation of your driving privileges. Michigan's super drunk law applies when your blood alcohol content reaches 0.17% or higher and allows judges to impose harsher penalties, including longer jail terms, higher fines, mandatory alcohol treatment, and a 1-year suspension with ignition interlock requirements. The court process moves quickly. After a traffic stop and arrest, you are booked and typically released on bond, arraigned within days, and then meet with prosecutors at a pretrial conference. If evidence is challenged through motions and no plea agreement is reached, the case goes to trial, and if convicted, the judge imposes a sentence, often including probation with testing and treatment conditions. Several defenses may help avoid conviction, such as challenging the legality of the traffic stop, questioning whether breath or blood tests were properly administered and calibrated, arguing that field sobriety tests were unreliable due to medical or environmental factors, or asserting that your blood alcohol level rose after you stopped driving. Michigan's implied consent law means that by driving you agree to submit to a chemical test if lawfully arrested. Refusing the official test triggers an automatic 1-year license suspension and 6 points on your record, and you have only 14 days to request a hearing to contest the suspension. Long-term consequences of an OWI conviction include higher insurance rates, possible cancellation of policies, difficulty traveling internationally, potential discipline by professional licensing boards, and limited opportunities to expunge the offense. During probation, you may be subject to ongoing testing and supervision fees, and violating any condition can lead to additional penalties. Because Oakland County prosecutors are known for strict enforcement and high conviction rates, having a skilled attorney familiar with local courts is critical to protecting your rights and negotiating for reduced charges or penalties. If you refused a chemical test or are unsure how to proceed, consult a lawyer immediately to preserve your ability to challenge the suspension and to explore possible defenses. Michigan Defense Law is a law firm serving Oakland County and nearby communities and provides strategic defense to individuals facing OWI and related charges. The attorneys at this law firm evaluate every detail of the traffic stop, chemical testing procedures, and court process to build a defense that addresses both the legal issues and the practical impact on your life. To discuss your case and receive guidance from an attorney, contact Michigan Defense Law at 248-451-2000. Michigan Defense Law is located at 2525 South Telegraph Road, Suite 100, Bloomfield Hills, Michigan, 48302, United States, and can be reached at 248-451-2000.